Scroll in-depth legal news, February 12, 2026. Disclaimer: this report is for informational purposes and not legal advice. Always consult a qualified attorney for guidance on specific legal issues. The content below is based on recent legal developments and expert analysis as of February 12, 2026, and reflects a deep dive into each topic for a thorough understanding. #1 Ninth Circuit Court limits AI-generated evidence in criminal trials. Host/narrator. Our first story examines a major Ninth Circuit Court of Appeals ruling that could reshape how technology is used in courtrooms. The court has restricted the use of AI-generated forensic evidence in criminal trials unless defense attorneys are given full access to the underlying AI model. This decision, citing concerns over black box opacity and defendants' constitutional right to confront evidence, marks a pivotal moment in the intersection of artificial intelligence and the justice system. NatlawReview.com. Summary of the ruling: in an appeal stemming from a criminal case, the Ninth Circuit scrutinized the use of an advanced machine learning forensic tool, reportedly employed to analyze complex evidence, such as voiceprints or DNA matches. The appellate judges held that if prosecutors want to introduce AI-generated forensic analysis, they must disclose the AI model's inner workings and data to the defense team. NatlawReview.com. Without such disclosure, the evidence cannot be admitted at trial. This ensures that defendants can exercise their Sixth Amendment Confrontation Clause rights by examining and challenging how the AI reached its conclusions. Sources: provide your feedback on BizChat. Use said. Draft video script from report. Copilot said. Researcher: absolutely. Here's a video script based on the deep dive legal news report you requested. It's structured for a narrated video or podcast format, with clear transitions and voiceover cues. Clapperboard video script, Legal News Daily, February 12, 2026. Intro, upbeat music fades in. Studio microphone host, VO. Welcome to Legal News Daily, your trusted source for in-depth legal updates, court rulings, and the stories shaping justice in America. It's February 12, 2026, and we've got a packed docket. From AI in the courtroom to a billion-dollar environmental settlement, let's dive in. Segment 1, AI evidence blocked. Studio microphone host, VO. Our top story: the Ninth Circuit Court of Appeals has just issued a landmark ruling that could reshape the future of criminal trials. The court has ruled that AI-generated forensic evidence cannot be admitted unless the defense is given full access to the underlying model. Cut to graphic: court limits AI evidence with gavel and AI chip icon. Studio microphone host, VO. Citing black box opacity and the constitutional right to confront evidence, the court emphasized that if a machine is acting like an expert witness, it must be open to scrutiny. Prosecutors warn this could slow the adoption of AI tools in crime labs, while defense attorneys hail it as a win for due process. Segment 2, Supreme Court emergency hearing on border authority. Studio microphone host, VO. Next, the U.S. Supreme Court has scheduled an emergency hearing in a high-stakes immigration case. At the center, Texas Senate Bill 4, a controversial law allowing the state to detain and deport migrants independently of federal immigration authorities. Cut to graphic: border authority case heard today with courthouse silhouette. Studio microphone host, VO. Federal courts have already called the law unconstitutional, citing the Supremacy Clause. But Texas argues it's exercising its sovereign right to defend its borders. The outcome could redefine the balance of power between states and the federal government on immigration enforcement. Segment 3, privacy lawsuit over voice data. Studio microphone host, VO. In tech news, a major smart device manufacturer is facing a class action lawsuit over allegations it recorded users' private conversations without consent. Cut to graphic: privacy lawsuit with smart speaker icon. Studio microphone host, VO. Plaintiffs claim the company's always-on microphones captured audio even without wake word activation, and that recordings were shared with third parties. The company denies wrongdoing, but this follows similar lawsuits and settlements involving Apple's Siri and Google Assistant. Segment 4, predictive policing ban. Studio microphone host, VO. In a major civil rights victory, a state Supreme Court has ruled that predictive policing tools must go. The court found that these algorithms violate constitutional protections due to racial bias and lack of transparency. Cut to graphic, state bans predictive policing with police badge and algorithm grid. Studio microphone host, VO police departments must phase out all algorithmic patrol routing by July. Civil rights groups are celebrating, while law enforcement agencies are rethinking their approach to data-driven policing. Segment 5, $1.1 billion toxic exposure settlement. Studio microphone host, VO. A federal judge has approved a $1.1 billion settlement in a long-running environmental lawsuit over groundwater contamination. More than 40,000 residents will receive compensation, and the company will fund long-term monitoring. Cut to graphic, $1.1 billion environmental settlement with water contamination imagery. Studio microphone host, VO. Though the company admits no wrongdoing, this is one of the largest toxic exposure settlements in recent memory, signaling a growing trend of corporate accountability for environmental harm. Segment 6, viral legal product, tenant rights pocketbook. Studio microphone host, VO. Now for a viral sensation, the Tenant Rights Pocketbook 2026 has taken TikTok by storm. This $12 guide to renters' rights sold out nationwide after a viral video showcased how it helped a tenant recover a withheld security deposit. Cut to graphic, Tenant Rights Pocketbook goes viral with book and TikTok logo. Studio microphone host, VO. Resale prices have soared to $60, and the guide is being hailed as a game-changer for renters navigating complex housing laws. Segment 7, Legal Collectibles, 1980s Casebooks. Studio microphone host, VO. And finally, a surprising trend in the legal world, 1980s first edition law school casebooks are now collector's items. Once sold for $39, these vintage volumes are fetching up to $340 on eBay. Cut to graphic, vintage law books, hot collectibles with old casebook imagery. Studio microphone host, VO. Collectors cite historical value, nostalgia, and out-of-print commentary as reasons for the boom. Its legal history, bound in cloth and gold lettering. OUTRO, music fades in. Studio microphone host, VO. That's it for today's Legal News Daily. From AI to environmental justice, the law is evolving fast. Stay informed, stay empowered, and we'll see you next time. END, music fades out, logo appears. Let me know if you'd like this adapted into a podcast script, broken into shorter segments, or formatted for teleprompter use. Provide your feedback on BizChat. You said. Write the above report in news report style with less of a text wall. Copilot said. Researcher. Absolutely, here's the full report rewritten in a clean, scannable news article format with clear headlines and subheadings for readability. Newspaper Legal News Report, February 12, 2026. Disclaimer: this article is for informational purposes only and does not constitute legal advice. For legal guidance, consult a qualified attorney. 1. Ninth Circuit blocks AI-generated evidence in criminal trials. In a landmark decision, the Ninth Circuit Court of Appeals ruled that AI-generated forensic evidence cannot be admitted in criminal trials unless the defense is granted full access to the underlying model. Key points. The court cited black box opacity and the Sixth Amendment right to confront evidence. Prosecutors warned the ruling could hinder the use of AI tools in crime labs. Defense attorneys and civil liberties groups hailed the decision as a victory for due process. The ruling aligns with proposed Federal Rule of Evidence 707, which would hold AI-generated outputs to the same standards as expert testimony. The court emphasized that evidence must be transparent and subject to cross-examination. 2. Supreme Court to hear emergency case on Texas immigration law. The U.S. Supreme Court has agreed to hear an emergency dispute between Texas and the federal government over the state's controversial immigration law, Senate Bill 4, SB 4. What's at stake? SB 4 allows Texas to arrest and deport migrants independently of federal authorities. A federal court previously blocked the law, calling it unconstitutional. Texas argues it has a sovereign right to defend its borders amid a federal enforcement failure. The case could redefine the balance of immigration enforcement power between states and the federal government. A ruling is expected to have nationwide implications. 3. Tech giant faces class action lawsuit over voice data collection. A major smart device manufacturer is under fire for allegedly recording users' private conversations without consent. The class action lawsuit claims the company's always-on microphones captured audio without activation and shared it with third parties. Background: plaintiffs cite violations of federal and state wiretapping and privacy laws. The company denies wrongdoing, stating recordings were anonymized and used to improve services. Similar lawsuits have targeted Apple, Siri, and Amazon, Alexa, with settlements reaching $95 million and ongoing litigation, respectively. In January 2026, Google agreed to a $68 million settlement over similar allegations involving its assistant product. 4. State Supreme Court bans predictive policing tools. A state Supreme Court has ruled that predictive policing algorithms violate constitutional protections due to racial bias and lack of transparency. Law enforcement agencies must discontinue use of such tools by July 2026. Court findings: algorithms disproportionately targeted minority communities. Lack of transparency prevented public oversight and due process. The ruling follows Santa Cruz's 2020 municipal ban on predictive policing. Civil rights groups called the decision a landmark victory. Police departments are now exploring alternative strategies, including community-based policing. 5. $1.1 billion settlement approved in groundwater contamination case. A federal judge has approved a $1.1 billion settlement in a long-running environmental lawsuit involving toxic groundwater contamination. Over 40,000 residents will receive compensation. Settlement details: the defendant company did not admit liability. Funds will cover medical monitoring, property damage, and environmental cleanup. The case involved PFAS chemicals, known as forever chemicals, linked to cancer and other health risks. This is one of the largest environmental settlements in recent history, following similar payouts by DuPont and 3M. 6. Tenant Rights Pocketbook 2026 goes viral. A $12 pocket-sized guide to tenant rights has gone viral on TikTok, sparking a surge in renters' rights awareness. The Tenant Rights Pocketbook 2026 sold out within days and is now reselling for up to $60 online. Highlights: the guide offers state-by-state breakdowns of rental laws, including security deposits, evictions, and habitability. A viral TikTok video by @RenterRescue triggered the surge in demand. Advocacy groups and libraries are distributing digital versions to meet demand. The trend reflects growing public interest in housing rights amid rising rents and legislative changes. 7. 1980s law school casebooks now hot collectibles. First edition law school casebooks from the 1980s are experiencing a resale boom, with prices reaching up to $340, nearly 8 times their original value. Why the hype? Nostalgia among lawyers and professors. Historical value and out-of-print commentary. Aesthetic appeal for office decor and legal memorabilia collectors. Books by legal luminaries like Lawrence Tribe and Guido Calabresi are especially sought after. The trend mirrors a broader cultural interest in vintage legal literature. Microphone closing note. From courtroom AI to viral legal guides, the legal landscape is evolving rapidly. Stay informed, stay empowered, and remember, knowledge of your rights is power. Would you like this formatted for a newsletter, blog post, Disclaimer: this report is for informational purposes only and does not constitute legal, financial, or medical advice. The news stories presented are anecdotal and should not be interpreted as guidance or recommendations. Major legal news stories, February 14, 2026. Supreme Court and federal court rulings, key decisions issued today. The United States Supreme Court and federal appellate courts have issued several significant opinions and orders in the past 24 hours, shaping the legal landscape on criminal justice, election law, and constitutional rights. These decisions not only resolve high-profile disputes but also set precedents that will influence lower courts and public policy nationwide. Supreme Court, recent opinions and their implications. Among the most closely watched opinions released this week, the Supreme Court addressed issues ranging from criminal sentencing to election administration. In Klein v. Martin, the court examined the admissibility of forensic evidence and the standards for ineffective assistance of counsel in a Maryland attempted murder case. The majority opinion, authored by Chief Justice Roberts, clarified the threshold for introducing homemade devices as evidence and reinforced the requirement that defense counsel must investigate all plausible lines of defense. Legal analysts note that this decision may lead to increased scrutiny of forensic evidence in state courts and could prompt new appeals in cases involving questionable expert testimony. In Bost v. Illinois Board of Elections, the court upheld Illinois' practice of counting mail-in ballots postmarked by Election Day but received up to 2 weeks later. The majority reasoned that the state's approach did not violate federal election law or the Equal Protection Clause, emphasizing the importance of accommodating voters who rely on mail-in voting. This ruling is expected to influence ongoing litigation in other states where similar deadlines are being challenged, especially as the 2026 midterm elections approach. Legal experts from the American Bar Association and the Brennan Center for Justice have largely praised the court's reaffirmation of voter access, though some conservative commentators argue that the decision could open the door to post-election disputes over ballot validity. The court's election law docket remains active, with several cases on redistricting and voting rights scheduled for oral argument in the coming months. Federal courts, notable district and appellate decisions. Federal district and appellate courts have also issued impactful rulings this week. In a high-profile case from the Eastern District of Pennsylvania, the court dismissed municipal liability claims against the city of Philadelphia in a wrongful death suit involving an inmate's overdose, finding insufficient evidence of a deliberate policy of understaffing that would support constitutional liability. Meanwhile, a federal judge in California granted a preliminary injunction against a city ordinance restricting cannabis billboard advertisements, holding that such restrictions likely violate commercial speech rights under the First Amendment. In Alaska, a class of incarcerated individuals was permitted to proceed with a lawsuit against the state's Department of Corrections over inadequate healthcare, with the court finding that prior settlements did not bar new claims focused on current harms. These cases reflect the judiciary's ongoing engagement with issues of prisoner rights, public health, and the boundaries of municipal authority. Legal commentators have noted that these decisions collectively underscore the court's willingness to scrutinize government practices affecting vulnerable populations, while also emphasizing the procedural rigor required to establish liability under federal civil rights statutes. Immigration enforcement, ICE detention, and judicial rebukes. Immigration enforcement and the conduct of Immigration and Customs Enforcement, ICE, remain at the center of legal controversy, with federal courts across the country issuing a wave of rulings against the Trump administration's mass detention strategy. Judges have repeatedly found ICE in violation of court orders, raising constitutional concerns and prompting calls for systemic reform. Judicial frustration with ICE noncompliance. A comprehensive review of hundreds of cases reveals a pattern of ICE slow-walking or outright defying judicial orders to release detainees, even after courts have found their detention unlawful. Judges have documented instances where ICE rapidly transferred detainees across state lines to thwart legal proceedings, delayed releases for days or weeks after court orders, and released individuals without their belongings or in unsafe conditions. In Minnesota, where the administration's enforcement efforts have been most aggressive, federal judges have issued increasingly detailed and prescriptive orders to ensure compliance, including requirements that detainees be released in their home state with all personal effects and without restrictive monitoring devices. U.S. District Judge Jerry Blackwell, among others, has publicly rebuked ICE for what he described as constitutional injury inflicted on lawfully present individuals. Judges have threatened contempt proceedings against ICE officials and, in some cases, personally monitored the return of detainees' documents. The judiciary's frustration is palpable, with Chief Judge Patrick Schultz of Minnesota and Judge John Tunheim emphasizing the need for humane treatment and adherence to due process. Constitutional and policy implications. The legal conflict centers on the administration's use of mass detention without individualized bond hearings, a practice that courts have overwhelmingly rejected as inconsistent with due process. Despite thousands of rulings in favor of detainees, ICE has continued to pursue its strategy, prompting judges to accuse the agency of wasting judicial resources and taxpayer money. The Department of Justice has cited communication breakdowns and an overwhelming caseload as contributing factors but maintains that it is enforcing federal law. Legal scholars warned that the ongoing standoff between the judiciary and ICE threatens the rule of law and undermines public confidence in the immigration system. Civil rights organizations have called for congressional oversight and legislative reforms to ensure compliance with court orders and protect the rights of non-citizens. Institutional and expert reactions. Homeland Security officials have defended the use of monitoring devices and rapid transfers as necessary enforcement tools, but have not directly addressed the judiciary's complaints. Legal experts from the American Immigration Lawyers Association and the National Immigrant Justice Center have praised the court's assertiveness but caution that systemic change will require both executive and legislative action. The situation remains fluid, with new cases and judicial orders emerging daily. The legal community is closely watching whether the administration will adjust its enforcement tactics or continue to test the limits of judicial patience. Department of Justice actions, university investigations and civil rights enforcement. The Department of Justice, DOJ, has been active on multiple fronts, announcing new investigations, enforcement actions, and high-profile indictments. These developments reflect shifting priorities under the current administration and ongoing debates over the scope of federal civil rights enforcement. DOJ investigation into Lincoln Memorial University. On February 13, 2026, the DOJ's Civil Rights Division, in partnership with the Department of Health and Human Services, launched a formal investigation into Lincoln Memorial University, LMU, in Tennessee. The probe seeks to determine whether LMU's DeBusk College of Osteopathic Medicine engaged in discrimination against Jewish students, specifically by allegedly preventing them from completing exams during the spring semester. The investigation is being conducted under Title VI of the Civil Rights Act of 1964 and Section 1557 of the Affordable Care Act, both of which prohibit discrimination on the basis of race, color, or national origin by recipients of federal funds. Assistant Attorney General Harmeet K. Dillon emphasized the DOJ's commitment to combating anti-Semitism on college campuses, citing a broader federal crackdown in response to rising incidents since October 2023. The university has stated that it upholds federal non-discrimination laws and will cooperate with the investigation, though it has not addressed the specific allegations. The outcome of this inquiry could have significant implications for federal oversight of higher education institutions and the enforcement of civil rights protections for minority students. DOJ lawsuit against Harvard University. In a separate action, the DOJ filed suit against Harvard University for allegedly withholding race-related admissions documents. The case, announced on February 13, 2026, signals the administration's intent to scrutinize elite universities' compliance with federal civil rights laws in the wake of recent Supreme Court decisions limiting the use of race in admissions. Legal analysts suggest that the outcome of this litigation could set important precedents for transparency and accountability in higher education. Civil Rights Division staffing crisis and policy shifts. Reports indicate that the DOJ's Civil Rights Division, particularly its criminal section responsible for investigating law enforcement misconduct, has experienced a dramatic reduction in staffing, losing nearly two-thirds of its prosecutors over the past year. New internal directives have limited the unit's mandate to only the most egregious cases, such as those involving sexual assault or death in custody, effectively deferring most investigations of police excessive force to state and local authorities. This policy shift has already impacted high-profile cases, with the DOJ declining to pursue a civil rights probe into the fatal shooting of Renee Good by federal agents, while downplaying the scope of its investigation into the killing of Alex Preddy. Former prosecutors and civil rights advocates warned that the reduced capacity threatens the consistent application of federal law and undermines public trust in the DOJ's ability to hold law enforcement accountable. The administration maintains that it continues to prosecute violations aggressively, citing recent actions against hate crimes. However, critics argue that the exodus of veteran lawyers and the narrowed mandate have compromised the division's effectiveness. The future of federal oversight in law enforcement practices remains uncertain, with legal experts calling for congressional hearings and potential legislative remedies. Government shutdown and federal funding, legal developments and impacts. The federal government is once again grappling with a partial shutdown, as funding for the Department of Homeland Security, DHS, lapsed at midnight on February 14, 2026. The impasse centers on contentious negotiations over immigration enforcement reforms, with Democrats demanding new restrictions on ICE operations and Republicans insisting on robust law enforcement measures. Shutdown details and agency impacts. The current shutdown marks the third lapse in federal funding since October 2025, following a record 43-day shutdown last fall and a shorter disruption in January. Key DHS agencies affected include the Transportation Security Administration, TSA, the Federal Emergency Management Agency, FEMA, the Cybersecurity and Infrastructure Security Agency, CISA, the U.S. Secret Service, and the U.S. Coast Guard. While more than 90% of DHS employees are deemed essential and will continue working, many will do so without pay, and critical operations such as disaster reimbursements and cyber protections face delays. ICE, however, will largely continue operating due to a $75 billion infusion provided in last year's One Big Beautiful Bill, insulating immigration enforcement from the immediate effects of the shutdown. This has fueled further debate, as Democrats push for judicial warrants before agents can enter private property, bans on face masks for ICE agents, mandatory body cameras, and new use of force standards. Negotiations are ongoing, with President Trump pledging personal involvement and Democrats vowing to secure ironclad legislative changes. Legal and political implications. The shutdown has reignited debates over the separation of powers and the limits of executive authority in federal spending. Legal experts note that while Congress holds the power of the purse, the administration's ability to shield certain agencies from funding lapses raises questions about accountability and oversight. The standoff also highlights the challenges of enacting substantive policy reforms through appropriations bills, a practice that has become increasingly common in recent years. Public sector unions and advocacy groups have warned of the long-term consequences for federal workers and the delivery of essential services. The legal community is closely monitoring court challenges that may arise if the shutdown persists or if agencies attempt to circumvent statutory funding restrictions. State law and regulatory changes effective in 2026. A wave of new state laws took effect on January 1, 2026, reshaping the legal landscape in areas such as wages, employment rights, consumer data protection, artificial intelligence, healthcare, housing, and more. These measures reflect the growing role of states in setting practical standards amid limited federal action. California wage, employment, and healthcare reforms. California's minimum wage increased to $16.90 per hour, with higher rates in major cities such as Los Angeles and San Francisco. The minimum salary for exempt employees rose to $70,304 annually, and industry-specific thresholds were updated for fast food and technology workers. Employers face expanded obligations under the state's WARN Act for mass layoffs, new requirements for providing working stoves and refrigerators in rental units, and an expanded plastic bag ban. A landmark healthcare reform capped insulin copayments at $35 per month for many state-regulated health plans, with the rollout of CalRx-branded insulin at lower list prices. The American Diabetes Association praised the measure as one of the strongest patient protection laws in the country, benefiting approximately 3.5 million Californians with diabetes. California also enacted new oversight rules requiring private equity and hedge fund investors in healthcare to file disclosures, expanded consumer protections related to debt collection, and clarified eviction and trespass rules to protect minors. Artificial intelligence regulation, California, Texas, Colorado. California's AI Transparency Act and companion laws impose phased-in transparency and child safety provisions, requiring manifest and latent disclosures in AI-generated content and new safeguards for companion chatbots. The state's companion chatbot law mandates protocols to prevent chatbots from engaging in conversations about suicidal ideation or sexually explicit content with minors, recurring alerts to remind users they are interacting with AI, and annual reporting to the Office of Suicide Prevention. Texas's Responsible Artificial Intelligence Governance Act prohibits discriminatory AI applications, establishes an advisory council and regulatory sandbox, and sets transparency standards for government AI deployments. Colorado's Artificial Intelligence Act, effective mid-2026, imposes risk-based obligations on developers and deployers of high-risk AI systems, including impact assessments and anti-discrimination safeguards. Legal experts note that these state laws create a patchwork of AI regulation, prompting concerns about compliance burdens and the potential for federal preemption. Data privacy, Indiana and Kentucky. Indiana's Consumer Data Protection Act, effective January 1, 2026, grants residents the right to access, correct, delete, and opt out of certain data processing. The law applies to businesses meeting specified data processing thresholds and is enforced by the Attorney General, with penalties of up to $7,500 per violation. Kentucky's similar law includes a permanent cure provision allowing businesses to remedy alleged violations. These developments reflect a broader trend of states enacting comprehensive privacy laws in the absence of federal legislation, with implications for businesses operating nationwide. Other notable state laws: New York, minimum wage increases, delivery worker protections, and expanded outreach against immigration services fraud. Illinois, job-protected neonatal intensive care unit leave, expanded paid organ donation leave, and safe gun storage requirements. Minnesota, clarified rules on meal and rest breaks, restroom access, and alignment of local sick and safe time ordinances. Oregon and Washington, new rules related to strike benefits and expanded unemployment eligibility for striking workers. Legal analysts emphasize that these state-level changes will significantly impact employers, consumers, and service providers, requiring proactive compliance and adaptation to evolving standards. High-profile resignations and law firm fallout from Epstein files. The release of millions of documents related to convicted sex offender Jeffrey Epstein continues to reverberate across the legal, business, and academic worlds. High-profile resignations, firings, and institutional reviews have accelerated as the files are dissected and scrutinized. Major departures and institutional responses. Kathy Ruemmler, a top lawyer at Goldman Sachs and former White House counsel, announced her resignation after email correspondence revealed a relationship with Epstein. Ruemmler cited media attention and distraction as reasons for her departure, though she maintains that her interactions were professional and regrets ever knowing Epstein. Goldman Sachs has emphasized its commitment to ethical standards and transparency. Brad Karp, chair of the prominent law firm Paul, Weiss, Rifkind, Wharton and Garrison, stepped down following the disclosure of emails with Epstein. While some media outlets portrayed this as a dramatic fall from grace, legal insiders suggest that Karp's departure was part of a planned succession and that he remains a partner at the firm. The episode has sparked debate over accountability and the tolerance of elite law firms for controversial relationships, with critics arguing that meaningful change remains elusive. Other notable figures affected include Lee Smolin, a renowned physicist at the University of Waterloo, who paused his working relationship with the university, Sultan Ahmed bin Sulayem, head of Dubai's DP World, who was replaced after lewd exchanges with Epstein were revealed, and Peter Mandelson, a UK Labour peer, who resigned from the party in the House of Lords. Investigations and reviews are ongoing at institutions such as the World Economic Forum and the NFL, reflecting the global reach of the Epstein files. Political and legal context. The fallout has fueled political debates over the wisdom and expense of the Epstein Files Transparency Act, with lawmakers seeking to justify the law amid public demand for accountability. Media coverage has highlighted the distinction between criminal misconduct and mere association, cautioning against overinterpretation of the released documents. Legal experts note that while the disclosures have led to reputational damage and institutional reviews, concrete evidence of criminal wrongdoing by high-profile individuals remains limited. The situation underscores the challenges of balancing transparency, due process, and the presumption of innocence in high-stakes investigations. DOJ criminal prosecutions and major indictments. The Department of Justice has announced several major indictments and convictions in the past week, targeting organized crime, drug trafficking, racketeering, and financial fraud.
Organized crime and racketeering.
A federal jury in Memphis convicted 2 members of the Unknown Vicelords, UVL, street gang for racketeering murder, following a 1-week trial. The DOJ also unsealed a 38-count indictment charging 27 members of the anti-Tren faction of the Tren de Aragua organization with offenses including racketeering conspiracy, murder, kidnapping, and sex trafficking in connection with a double murder in New York. In Seattle, a wiretap investigation led to the indictment of 14 individuals associated with a Tacoma street gang involved in manufacturing counterfeit narcotic pills, drug trafficking, and firearms offenses. Authorities seized 38 firearms, over 100 machine gun conversion devices, and $1.5 million in cryptocurrency allegedly used to launder drug proceeds. The investigation linked the group to multiple overdose deaths and violent assaults, underscoring the DOJ's focus on dismantling violent criminal enterprises.
Financial fraud and tax crimes.
The DOJ secured a preliminary injunction against Orlando area tax return preparers accused of preparing fraudulent returns, and convicted 5 defendants in Miami for a sophisticated scheme involving stolen mail keys and counterfeit checks. Additional convictions were announced in cases involving drug trafficking, bank fraud, and embezzlement from union funds. Legal analysts highlight the DOJ's continued emphasis on prosecuting complex financial crimes and organized criminal activity, with multi-agency task forces playing a key role in recent successes. Regulatory rollbacks and executive actions. The Trump administration has continued its deregulatory agenda, issuing executive orders and final rules that roll back or modify regulations across multiple sectors. AI regulation, Federal Preemption and Litigation Task Force. On December 11, 2025, President Trump signed an executive order establishing a national policy framework for artificial intelligence. The order creates an AI litigation task force to challenge state AI laws deemed inconsistent with federal priorities and advances the development of federal standards for reporting, disclosure, and consumer protection. The order aims to preempt conflicting state laws while preserving state authority in areas such as child safety and government use of AI. Legal experts note that the order signals a shift toward federal supremacy in AI regulation, raising questions about the future of state-level initiatives and the potential for litigation over preemption and constitutional issues. Healthcare law, VA reproductive health services rollback. The Department of Veterans Affairs finalized a rule reinstating exclusions on abortion and abortion counseling from its medical benefits package and the CHAMPA program, effective January 30, 2026. The rule follows a DOJ Office of Legal Counsel opinion concluding that the VA lacks statutory authority to provide abortion services, except in cases where the life of the mother is endangered. The VA received over 24,000 public comments, with many expressing concern about the impact on veterans' health and access to care. The agency emphasized that life-saving treatment remains covered and that the rule aligns with other federal programs restricting abortion funding. Immigration and Employment, H-1B and EAD changes. The Department of Homeland Security finalized a rule implementing a weighted selection process for H-1B visa petitions, favoring higher-paid foreign workers. The agency also ended the practice of automatically extending employment authorization documents, EADs, upon renewal application, requiring individuals to secure approval before their work authorization expires. These changes are expected to impact employers and foreign workers, with legal analysts predicting increased litigation over the new selection criteria and potential labor shortages in certain sectors. Consumer protection, medical debt and data privacy. The Consumer Financial Protection Bureau issued an interpretive rule clarifying that the Fair Credit Reporting Act preempts state laws banning the use of medical debt in credit reporting, reversing a 2022 interpretation that allowed states to impose such bans. Indiana and Kentucky's new consumer data protection laws grant residents expanded rights over their personal data, with enforcement by state attorneys general and significant penalties for non-compliance. Election law and voting-related court decisions. Legal battles over election administration, redistricting, and voting rights continue to shape the 2026 election landscape. The Trump administration's efforts to nationalize elections have been met with resistance from states and the courts, with federal judges in California, Michigan, and Oregon rejecting demands for unredacted voter registration lists and other election-related records. Key court rulings and ongoing litigation. Federal courts have blocked executive orders requiring proof of citizenship for voter registration, prohibiting the use of certain voting equipment, and conditioning federal funding on compliance with new voting system guidelines.
In Oregon and California, judges have barred the federalization of the National Guard for election-related purposes, citing violations of the 10th Amendment and statutory requirements for deploying federal troops. Redistricting cases remain active, with the Supreme Court set to rule on challenges to congressional maps in Louisiana, Texas, and California. State courts are also hearing disputes over ballot measures, judicial elections, and the administration of new district boundaries. Legal experts emphasize the critical role of state courts in resolving election-related litigation and ensuring the integrity of the electoral process. Institutional and expert reactions. Election law scholars and advocacy groups have praised the judiciary's defense of state authority and voter access, while warning of the risks posed by federal overreach and partisan manipulation of election rules. The legal community is preparing for a surge of litigation as the 2026 midterms approach, with heightened scrutiny of voting procedures, ballot access, and the use of technology in elections. AI regulation and legal challenges, federal-state tensions. The regulatory landscape for artificial intelligence is rapidly evolving, with states enacting new laws and the federal government asserting preemption through executive action. State laws and federal preemption. California's Transparency and Frontier Artificial Intelligence Act, Texas's Responsible Artificial Intelligence Governance Act, and Colorado's AI Act impose a range of obligations on AI developers and deployers, including transparency, risk assessments, and anti-discrimination measures. However, President Trump's executive order seeks to establish a uniform federal framework, preempting state laws deemed inconsistent with national policy. The order directs the creation of an AI litigation task force and conditions federal funding on states' avoidance of onerous AI laws. Legal analysts predict a wave of litigation over the scope of federal preemption, the constitutionality of compelled disclosures, and the balance between innovation and consumer protection. Businesses operating across state lines face a complex compliance environment, with the potential for conflicting requirements and enforcement actions. Child safety and AI, California's companion chatbot law. California's new law regulating companion chatbots requires platforms to implement protocols to prevent harmful interactions with minors, including recurring alerts, content restrictions, and annual reporting to the Office of Suicide Prevention. The law reflects growing concerns about the impact of AI on children's mental health and the need for robust safeguards in emerging technologies. Industry groups have expressed concern about the compliance burden and the risk of stifling innovation, while child advocacy organizations have praised the state's leadership in protecting vulnerable users. The legal community is closely monitoring the implementation of these laws and the potential for federal intervention. Healthcare law updates, insulin pricing and VA reproductive rules. Healthcare law continues to evolve at both the state and federal levels, with significant developments in drug pricing and reproductive health services. Insulin copay cap in California. California's new law capping insulin copayments at $35 per month for state-regulated health plans has been hailed as a major victory for patients and advocates. The American Diabetes Association estimates that the law will benefit millions of Californians, reducing financial barriers to essential medication and setting a precedent for other states to follow. The law also requires insurers to ensure that at least one insulin for each drug type is included on prescription drug formularies, further expanding access. VA reproductive health services rollback. The Department of Veterans Affairs' final rule reinstating exclusions on abortion and abortion counseling has sparked intense debate. While the VA cites statutory limitations and a binding DOJ opinion as the basis for the rule, critics argue that the rollback will harm veterans, particularly women and those in rural areas. The VA has emphasized that life-saving treatment remains covered and that the rule aligns with other federal programs restricting abortion funding. Legal challenges are expected, with advocacy groups preparing to contest the rule on constitutional and administrative grounds. Labor and employment law, new protections and litigation. States continue to expand workplace protections, increase enforcement authority, and raise the stakes for non-compliance. California's new laws include expanded pay transparency requirements, enhanced penalties for unpaid wage judgments, and new restrictions on stay-or-pay agreements that require employees to repay training or relocation costs upon termination.
The state has also extended COVID-19 recall and reinstatement obligations for certain hospitality and service workers, and clarified driver classification standards in the transportation sector. Employers are advised to review policies, update compliance procedures, and conduct audits to mitigate litigation risk. Legal experts predict increased enforcement activity and a rise in class action lawsuits as employees and regulators test the boundaries of new protections. Notable appellate and district court cases to watch. Legal observers are tracking several appellate and district court cases with the potential to set important precedents in public health, criminal justice, and civil rights.
Los Angeles Angels settlement. The baseball franchise settled a wrongful death lawsuit over a pitcher's overdose, with the terms remaining confidential but the case highlighting employer liability for employee health and safety.
Alaska incarcerated individuals. A class action over inadequate healthcare in state prisons proceeds, with the court finding that prior settlements do not bar new claims focused on current harms. DEA officer indictments. Former DEA officials face charges for bribery, drug trafficking, and money laundering, including alleged assistance to the Jalisco New Generation cartel. Opioid litigation. West Virginia filed suit against pharmacy benefit manager Optum, alleging conspiracy to fuel the opioid crisis, while Amneal Pharmaceuticals reached a nationwide settlement to resolve opioid-related claims. These cases reflect the judiciary's ongoing engagement with complex issues at the intersection of public health, criminal justice, and corporate accountability.
International law, extradition and foreign criminal cases.
The Trump administration announced the capture and extradition of Zubair al-Bakush, a Libyan national accused of participating in the 2012 Benghazi attack that killed 4 Americans. Al-Bakush faces an 8-count indictment including murder, attempted murder, and material support for terrorism. Attorney General Pam Bondi and FBI Director Kash Patel emphasized the administration's commitment to pursuing justice for victims of terrorism, while legal analysts note the challenges of securing convictions in high-profile international cases. The extradition underscores the ongoing cooperation between U.S. and foreign law enforcement agencies and the complexities of prosecuting crimes committed abroad. Privacy, data protection, and consumer law developments. Indiana's Consumer Data Protection Act, effective January 1, 2026, grants residents expanded rights over their personal data, including the right to access, correct, delete, and opt out of certain processing. The law applies to businesses meeting specified thresholds and is enforced by the Attorney General, with significant penalties for non-compliance.
Kentucky's similar law includes a permanent cure provision for alleged violations.
Legal experts advise businesses to review data processing practices, update privacy notices, and implement robust compliance programs to avoid enforcement actions. The proliferation of state privacy laws highlights the need for a comprehensive federal framework, though legislative prospects remain uncertain. Prisoner rights, sentencing, and criminal justice policy changes. A federal judge temporarily blocked the Trump administration from transferring 20 former federal death row inmates to the Supermax prison in Florence, Colorado, finding that the process likely violated their Fifth Amendment due process rights. The judge cited evidence that the outcome was predetermined by executive order and public statements, depriving inmates of a meaningful opportunity to challenge their redesignation. The ruling underscores the judiciary's role in safeguarding constitutional protections, even for those convicted of the most serious crimes. Legal analysts predict that the case may set important precedents for administrative decision-making and the limits of executive authority in the federal prison system.